can hear us.
All right, we're back for real this time.
Ready to rock and roll.
And this is a whole new broadcast, so I should just introduce everybody again as if nothing happened. None of you have any idea what we all just went through. So I've got John Wood. This is the Listen to This Bull live show. My name is Matthew Mulholland. This is Remington Huggins, Squire. This is the show where you get to ask us questions and our guest questions, and we'll all answer any question that you send to us, unless it's really personal. But even then, sometimes we'll get into it. Who knows? We're a little bit weird.
We'll give it our 2 cents.
Yeah, we will. So John Wood is an attorney that has just moved to Texas. I'm sure he works in a lot of other states. He's really got a nice hat. It's beautiful. And he is a board member of AAA, the American Adjuster Association. John, that hat is awesome.
Thank you.
Groovy.
You inspired.
I love it. I'm excited today because we have you inspire a lot of people.
Yeah, it's the hat. It wasn't even me. Hey, we even got some viewers back. That's great.
There we go. I'm pumped about today because we have 2 attorneys on. We can bounce things off of each other, John and I. And then I want you, Matt, obviously, to give your input from a public adjuster standpoint. So
I personally want to see y'all lawyer the heck out of Matt.
Okay. Should we put him in a deposition? Should we do that?
Yes,
we can.
absolutely.
I've done too many of those. Never deposed a public adjuster, though. I don't think I ever will. Hopefully.
You've never deposed? Well, you're not on the defense counsel.
Right.
Why would you depose a public adjuster?
That's a great question. That's why I said I never want to. Hopefully I never did.
John, have you ever deposed a public adjuster?
I personally have not, but there is a time and a place for taking a friendly deposition where you just want to get your own expert under oath. So I can imagine taking a deposition of a PA as a fact witness just to have their own testimony under oath and in the record. It's certainly not a typical posture in your case. You're usually taking depositions of adversaries, but I could see a scenario where it makes sense.
Like a summary judgment type situation where you're looking forward to it and you want some, instead of an affidavit, you want some on the record testimony.
Yeah, exactly. There's a time and a place for it.
Absolutely. I'd agree to that. Like you said, though, that's very unusual. I've done that before. Typically, I'll just get a affidavit. If the defense counsel doesn't do their job and notice a deposition of particular witnesses on our side. And I always said this, and I had to say this actually in federal court 2 weeks ago, where the insurance company cannot benefit for them not actually doing their job and noticing depositions of witnesses on our side and try to benefit from that. That's why I, entered in affidavits and so forth. Mm-hmm. They'll do that. They certainly will.
Is this how you usually feel on my show? Like a third wheel, a little bit?
Third wheel? No.
There's like a little bit of, there's definitely a lot of attorney talk going on over here.
Oh, hey, Matt's getting a little jealous over here, John.
I was saying, if this is how you feel normally, I feel like a piece of shit. I'm sorry.
It's just some lawyer lingo, but we will actually change positions here.
It's actually great because we don't really get a chance to go through a lot of this stuff. I didn't know you could even do that or even should. So it makes sense on the stand. I guess from a layman's point of view, you could call your own witness of being someone that's your client onto the stand, but would you? I don't know. But you don't know of someone that has done that.
There's a difference between calling somebody on the stand and taking their deposition. This is a whole different ballgame.
Pause for 1 second. Move one thing out of the way so I can actually see.
Hey, John, I asked you a question earlier. I couldn't hear you, but what states do you practice in?
So I'm personally licensed in New York and Texas, but the law firm is in about 20 different states right now. We've got active litigation across the country. We pursue large loss litigation in any state through our network of trial attorneys and the American Board of Trial Advocates. But in a state like Texas, Florida, or Colorado, because of the presence and longstanding practice experience we have there, we'll take smaller end cases. Outside of those 3 states, it's usually large loss only, like high 6-figure, 7-figure cases. But we're a nationwide firm. That's how we think of ourselves. Obviously, we work with local counsel, fully compliant in that way. But this is a niche area of law. And so we find it helpful to property owners across the country to make our services available.
I love it. No boundaries. No boundaries. I love it.
How does Remington feel about your GKW hoodie? This is a green Klein and wood. That wood down there, that's that's that guy over there.
Here,
That's him.
I'm going to give you two different answers. Here's the political answer. I'm just glad we're all working together, moving this profession forward. I don't care if you have a hoodie or not. The truth is, I am jealous. And I'm upset about the situation.
Oh,
Well,
I need to
have beer mugs.
Yeah,
you got the
how do you
brand.
feel about it? It feels like butter. So if you were wearing one, you'd feel great about it. And I'll have to hook it up.
Oh, it's so nice.
There you go.
I don't really want to get too in depth on how it feels because it's going to get weird if we do. But it's really
It already
nice.
is.
Yeah,
We're trying to keep
You've already breached it.
Please.
I mean, I think the opening comment. Yeah, there you go.
It's pretty nice. I tried to wear this on the airplane, but on the way back from Texas, it is a little bit snugger than I had hoped. Maybe I'm a little bit fatter than I had hoped.
It's been on the COVID-10, huh?
So
Wait, just try and dunk
Is
a
that a
basket.
It
You'll lose
is.
weight real
It is a
fast.
thing. It's true.
how are you doing with that? Are you up to 10 feet yet? Right.
Yeah, I'm making progress. Yep, I can pull a rim down at 10 feet. I can get a tennis ball. This is like this big, and now a mini ball. It's like a 5-inch diameter ball. I can dunk that. My next stop is a soccer ball. So I'm just constantly pushing that boundary, and it just mentally, it's a huge challenge. But I'm making steady progress.
Does the diameter of the ball make a difference on how high you have to jump?
Absolutely.
Yeah,
100%.
yeah.
Makes sense.
You have to get the entire
ball.
ball over
That's
the
never
rim.
played basketball before.
Yeah. So so basically the rim is at 10 feet, and I'm hitting the rim like right here. Now to dunk, I have to hit the rim like right here. So I still have a couple inches left in my gains before I'm going to be able to throw a basketball down. There's only so much tendon strength you can gain in a year before you break something. But I'm pushing, every day I'm pushing myself and trying to get those gains.
Let me ask you a question. If you jump and dunk, for 5 minutes straight, do you just slowly lose height as you get tired? Is it segmented, or is there a steep curve where suddenly you just can't jump at all?
It's interesting. The first few minutes where you're jumping, I'm not dunking. My muscles are warming up. I'm getting more explosive, and then after maybe 10 minutes of effort, then I'll get that first dunk, and then I'll hit every single one for a while. So it's really about just how your body's responding, how elastic it is, how much explosiveness do you have, and so after I get warmed up is when I actually start dunking, and then my endurance is pretty high, and actually just need to gain more fast twitch muscle fiber. I've got plenty of slow twitch, so my endurance is high. It's just a matter of getting that pop, and that's what I'm working on now.
What are you laughing about?
It's funny we're having this conversation. Is this is this real?
This is
okay.
This is this show.
Okay. I just didn't know if this is really a goal for John here in 2021 is to be able to throw it down. I didn't know. That's awesome.
Yeah. I'm on a dunk quest. I've kept my eyes on the horizon.
I didn't realize.
That's so funny. Yeah. Surprising, this 34-year-old Caucasian lawyer is trying to dunk a basketball. A super difficult goal for anyone, period. But it was a reach goal, literally a reach goal, as a fundraiser for the American Policyholder Association that has taken on a life of its own, and it's gotten me into the best shape of my life. And I'm actually getting close to it, but it's not easy, and that's why I picked it. But it's kept me focused and disciplined through a difficult year.
That's awesome. I love it. I love it.
So at Win the Storm conference at the end of March, there is a basketball game, and there's a competition between two teams that the first game was last year, wasn't it?
That's right. That was their inaugural Win the Storm
John's on
basketball
the team.
contest. Yeah, and the idea is to get everyone into the
so he's on the team,
conference.
and he made it up.
Yeah, get everyone in the night before, have a family-friendly event, an athletic competition. Competition breeds excellence, and it's really cool. You end up on a team with people that professionally were competitors, but now we're on a basketball team together. The camaraderie was great. The energy was super high. We had over 100 people came out to the game last time. We're going to have even more now. The convention at Win the Storm has a basketball arena inside the lobby of the hotel. So we're going to be right there before the conference kicks off.
Oh.
Hey, John, if you can hear us, you're a little spotty there on your connection.
It's
No, I can hear you fine.
Is it?
Yeah.
Yeah, I can hear you guys loud and clear.
Okay.
All right.
Good.
Sorry about that. Is it just our computer then? It's working out fine on your end?
Hey, John, you're on the board of AAA. Tell me what's going on over there. What do you guys? What are some of your goals?
So the American Adjuster Association was created to be a consumer-centric lobbying organization for a nationwide presence, and we've got a couple main objectives. One of them is to serve as the first line of defense when the insurance lobby tries to erode policyholder rights. And what we're going to set up is a lobbyist in the state house of every state in the U.S. that has significant claims activity, just to let us know if tort reform is coming, if insurance code amendment is coming, so we can get stakeholder input and push back on that from a consumer of insurance product perspective. And then that's from the defensive side. And on the offensive side, what we're trying to get ensconced in the insurance code is a adjustment cost balancing, so that the reasonable costs incurred by an insured to try and get their payment at the right amount will be reimbursed on top of the loss. And that really follows from the fact that the practice of public adjusting is the carve out of a practice of law. And in the practice of law, in many states, the non-breaching party to a contract dispute is entitled to have their attorney's fees recovered, as well as foreseeable consequential damages. And I'd say that the law on consequential damages has been around for several centuries, so this should not be a foreign concept. What we're saying is if the insurance company denied a claim in whole or in part, and that forced the policyholder to hire a PA or to go to appraisal, those costs should be reimbursed by the carrier. So those are our two main lobbying objectives.
I love it.
Defensive and offensive.
So the stance in Florida, essentially big picture, AAA is trying to expand that to all 50 states at the end of the day.
Well, there's a lot about the Florida legal environment that we don't want to see in other states, but there are certain pro policy.
When I'm talking about the attorney's fees, and the statute and so forth.
Yes, and that's especially important when it comes to the residential claims. And these are the smaller claims that often get neglected. But if you look at the overall population, the vast majority of insurance claims filed in America are small residential claims. And no matter how good the legal environment is, those tend to find fewer PAs that can help them, fewer lawyers that can help them. And so the roofers are sort of left to their own devices to try and help their small residential claims clients. And then you get defense attorneys coming in and prosecuting these roofers for trying to help their clients out when no one else will. So this is to level the playing field. If we can have those adjustment costs reimbursed, it makes it much more viable for a PA to take on a residential loss, and it makes it easier for the roofer to refer their client to a PA without the heartburn of, I'm going to lose 10% of my margins here. We see this as a meaningful way to address the market failure that we're experiencing in many jurisdictions today.
It seems like it would be a really difficult thing for a lobbyist to argue that this is bad, that there should not be any reason that an insurance carrier would have to pay these additional fees for someone just because they intentionally did something egregious to the insured. I mean, they should be allowed to do that, right? Insurance carriers should be allowed to screw people, shouldn't they?
Well, that seems to be the prevailing attitude. And anytime a lobbyist says, hey, we need to protect the policyholders, they go cry wolf and they start screaming about how it's going to hurt their raised premiums. But that is outright deceptive and misleading. Insurance carriers are experiencing record high profits. They're experiencing windfall profits. And 2020, as bad as that was for the overall economy, was great for the insurance industry because when everyone stays home, the risk levels go down. And did they give premium reimbursements? No, only the auto companies did. And sometimes they were compelled to by the regulators. So, this is a reasonable, sensible proposal. It flows from the doctrine of consequential damages, which goes all the way back to Hadley versus Baxendale. In fact, it goes even further than that. There's like an Italian jurist in the 1500s that articulated the theory of consequential damages, that the breaching party is liable for the foreseeable costs that their breach imposes on their counterparty. And we're just trying to make that payment automatic. You should not have to go hire a lawyer to go give you a right that has been part of the common law for hundreds and hundreds of years.
So the goal, this isn't similar to Florida then. This isn't or even Texas. You shouldn't have to file a lawsuit in order to achieve these damages.
No, they should be paid automatic.
The second that an insured incurs this cost because of the insurance carrier's bad actions or lack of action, negligence, it should be automatic that this is owed. How would it be triggered? Is the insurance carrier just going to say, oh, we agree, you really did need to get a PA?
Well, if they make a payment that is in excess of their initial payment after the insured has hired professional representation, then that would be the trigger. Once you've opened up coverage, you've made a payment, you need to pay that extra consequential damages as well. Now, the law is written in Texas, the carrier shall pay prompt payment penalty interest for delays. Now, of course, they don't. And the insurance carrier's attorneys will say, I'll pay it when when my client is ordered by a court to pay it, which is not what the law says. Okay, so that's not right. And unfortunately, a lot of times people do need to lawyer up in order to get these damages. But it's important to have the law on the books because then at the very least, you have something to make a claim against. Now you have a legal hook to hang your case from.
I can't agree with you 100% more what AAA is trying to do and actually big picture, getting into legislation, actually changing laws for the benefit of policyholders and consumers across the 50 states. I just did something very simple. Okay, everybody out there. And what I'm trying to show you of what AAA is trying to do and change the laws and actually putting incurred cost back into the policyholder's pocket. This is what happens if you don't. This is a Georgia example for a situation. I don't know if you can see this, but a $20,000 roof case. Okay.
He's got a legal pad,
a $20,000 roof case. Let's say the public adjuster, 15%, there's $3K out the door. The attorney, 30%, there's $6K out the door. File a lawsuit, serve it, $500. 2 depositions. I'm saying 2. That's $1,500 a piece. That's $3,000. You have to hire an engineer to combat the insurance company's engineer. That's $2,000. Best day in court for that homeowner is to net $5,500. That's the best day in court.
$20,000
out of a $20,000 loss. It's right here, and I see it every day, and it's so hard for me sometimes, John, because I'm in this state where we don't have the statutes like you do in Florida and some of these other states where this is reality. This is what I have to face. And this is why I can't take $20,000 roof claims, because at the end of the day, the law firm's going to be losing money. And the amount of days and times answering discovery, sitting in for depots, and also, I mean, the big goal of all this is to have that actual homeowner put a roof on their house that was damaged from a covered peril. And they can't.
That's not happening.
That they are getting 25% off a roof after taking all of these risks. So
forget about the deductible.
And you know what? If the jury takes the deductible into place and they take, let's say it's a $2,000 deductible, they're netting $3,500 at the end of the day.
So they're coming out of pocket more to actually do the roof after getting an attorney involved than they would have if they just accepted whatever the initial offer was from the carrier. And then as an attorney, if there's an initial offer of $10,000, are you only able to charge on that delta, the $10,000?
Well, law firms have their different fee percentages. I only take a percentage off of new money that we're able to obtain from the onset of taking on that actual client going forward.
Remington's an ethical guy.
That's what we do. Other law firms have different.
I didn't know
structures.
if that was a legal requirement or anything like that.
Got it.
It's good form. It's good form to do it. I mean, this is a contract between a lawyer and the client, but as Remington's saying, his firm's policy is to do that, and I respect that. I think that's the right thing to do, and I appreciate you breaking it down, Remington. Those numbers are scary, and that's right. I mean, and if you're the audience, if you're listening to this and you're thinking, how are you supposed to do the job with that? That doesn't make any sense. You're right. It doesn't make any sense. It's a total market failure. That the insurance company would take a family's premiums, insure them, and then when they've got $35,000 in coverage, $50,000 in coverage, $100,000 coverage for the whole dwelling, the insured has a $20,000 roof claim, and instead of just paying them the $20,000 less the deductible, they say go pound sand, and now the insured has to hire an attorney or an adjuster or appraiser costs. Appraisers half the umpire costs, engineering expenses. And the juice isn't worth the squeeze. And so even the most zealous advocates would have to say, look, we can't help you here. And so those claims just go unpaid. And what that does is it leaves these middle class and lower middle class families with leaking roofs. And they got brown stains on their ceilings because they can't afford to fix the roof and pay their medical bills. Okay, and that's unfair and it's illegal. And it's a market failure. And that's why the AAA exists, because we're trying to find a way to address that market failure. And it's in part created by the fact that unauthorized practice of public adjusting rules keep roofers from advocating for those clients. It would be a crime in certain jurisdictions for a roofer to advocate for Mrs. Smith in her 2-bedroom home to get a new roof on. And so their only recourse as a contractor is to recommend Mrs. Smith hire Remington, hire me, hire a PA or something, or invoke appraisal. But then you're really limited to what the legal environment gives you. So that's why we're having to make a meta play here. We can't just keep going into court here and doing one-off cases because you're limited by what the legal environment gives you. We're having to go big picture and say we need to adjust the legal environment because it's not giving insureds a path to indemnity. And that's the whole purpose of insurance, is to be made whole after a loss. And if you got a $20,000 loss and you're covered for it, it's a covered peril, and you're only getting $5,000 at the end of the day, that's not indemnification. That defeats the purpose of insurance. And so we're hoping we have lawmakers will give us an audience and will entertain a reasonable, sensible proposal that can help make people whole again.
Let me ask you a question. On this $20,000 loss example, the defense counsel, the carrier's attorney, what do you think would be the average cost of that attorney for the carrier, roughly?
That's a good question. And like John and I talked about earlier, every firm has their different structure, but it's going to cost them more to defend this case than it is to pay it out. And I say that because, especially if they go into motion practice and there's summary judgments and limines and things like that. I mean, just a summary judgment I know costs anywhere from $7,500 to $10,000 for a defense counsel to even file that and get paid for doing that.
I think there's a strategy here, though.
Yeah,
there's a strategy here to the defense bar, and I think this is really sort of insidious. And the idea is settle those cases that bring forward counsel that knows what they're doing, that's got experience in first party litigation practice, but deny those that don't.
I love that.
Because at the lower end of the spectrum here, you have a harder and harder time as a policyholder to hire an attorney like Remington that knows what they're doing. So you end up asking your cousin who practices divorce law if they'll help you. And they're like, okay, I guess I'll help you. And then they go and try a case and they set that precedent. And then that becomes the law. So the defense bar just waits for the right case and then they'll try it, because then they get to set bad precedent. So it's really, it is insidious. At the end of the day, there is a rationale for why the carrier would pay more for their defense bills than the total value of the claim, and it's because they're looking to set precedent. They're always playing chess here, so we can't afford to play checkers. The days of divide and conquer, we have to overcome those. Roofers and PAs and attorneys all need to realize if the policyholders' rights are eroded, that's going to undermine all of us. So we have to protect the policyholder here from more tort reform, and that's going to keep us in business so we can continue putting these roofs back on and continue regenerating the economy after a loss and ultimately fulfilling the purpose of indemnification.
I'm going to piggyback off of what you said, John. And it's a cost-benefit analysis is what they do. Look, these guys are smart over there at the insurance companies, the State Farms, you name it. They say if I spend $100,000 on attorney's fees on this $20,000 case, that's going to save me money in the long run with years and years and years of potential bad precedents that's set for the policyholder and so forth. And that's what that's why they put so much money into defending some of these, small valued cases. I mean, it is.
We've got a question from the audience. If we were playing give something, get something, would it be unthinkable to hold public adjusters to the same barratry standards as attorneys in the give something category?
I'm not sure I understand. We're not playing games here. We're not playing give something, get something. We're talking about making clients whole again. They are entitled to the benefits of their insurance policy. Okay, they paid good money for that policy, and what we're trying to stop are these little tactics of death by 1,000 cuts that keep the insured from actually getting something, i.e. the benefit of their policy. So that's really our goal here. Now, with regard to barratry, a law firm is prohibited from ever giving something of value in exchange for a referral. I'm not sure if the same standard applies to public adjusters, though. PAs are held to the fiduciary duties, which is the highest standard of care imposed by the law. PAs have a duty of care and loyalty to their clients. They can't do something because of the kickback they're getting. They have to do what's in the best interest of the insured. So there is quite a bit of overlap with the ethical standards, although lawyers are generally held to a higher standard of discipline.
I want to jump on we have to do or act in the best interest of the insured. In this legal pad example, by the way, John, do you carry a legal pad everywhere you go?
Yes. And a pen. This is like
I do it. All of you do.
Yeah.
Every single one of you.
But
only the good ones. Only the
if you're a
good
lawyer,
ones.
You have to carry a pen. You got to carry a legal pad.
That's so funny.
The more ideas you have.
That's so funny. I don't get it. I don't understand why. I think you're all taught this at lawyer school. Probably. Anyway, in this example, $20,000 claim, as a public adjuster, if I know this is the likely outcome and the insured is going to end up with less money in the end, it's not really in their best interest to go down that path unless zero coverage was afforded. Why would I ever do this? And should I ever do this to someone?
Well, therein lies the rub. I mean, that's why these people can't get help, is because if you actually do the analysis, and the most successful attorneys are doing this before they sign up a claim, they're saying, what is the likelihood of a recovery? And we make this sort of napkin math forecast every day, and so that's really the problem here, and that's why I'm calling it a market failure, because you have a contract. The carrier's liability has been triggered by the covered peril happening, and yet nonetheless, there's no funds flow. That money that's supposed to be flowing through the pipeline of the economy is not coming. And so that just depresses the property values in the areas affected by storms. Those are roofing jobs that are not getting done. So it depresses the economy. And then the policyholder, they've got to decide, do I spend money on this valid thing or do I spend it on my roof? And so they're not purchasing what they should be. So it creates a massive drag on the economy. And it stuns me how the Chamber of Commerce gets behind the insurance industry on this, because every business in the Chamber of Commerce is a policyholder. They're all insured. And yet they let one member of the Chamber of Commerce, the insurance company, dictate their whole legislative approach here. Because generally businesses say, hey, I don't like being sued. I agree with State Farm here. Let's make it hard to sue us. Let's make it hard to sue State Farm. But they got to get smarter about that, because every business in the Chamber of Commerce is a policyholder. In fact, almost everyone in America is a policyholder. If you drive a car, you're insured. If you've got a mortgage for your house, you are insured. And so, to talk about policyholder rights is almost like talking about constitutional rights or human rights, given how pervasive that there's almost a total overlap. If you're an adult and you drive a car or you own a home or you are a business, you are an insured. So we have a lot in common and a lot to fight for.
Yeah. So you've got this language with the AAA. I've seen the language. It's a simple statement. It's one sentence long, and it basically shifts any fees that the insured may incur in order to prove their loss or at least deal with an insurance carrier who has denied or acted poorly against them. And it's so simple, being one simple sentence like that. What do you think the outcome is in a state if they were to send that language to legislation as a bill and try to get passed? What do you think the insurance carrier is likely to be able to achieve? Do you think they'd be able to kill it or adapt it? What do you think the outcome will be?
It really depends on the political environment of where we're operating. And I just want to be precise here. The proposal is reasonable costs that are incurred after a denial in whole or in part and after the carrier has made a claim. So this is only in the situation where the carrier has broken the law and then paid what they should have paid. So they've confessed that they were liable in the first place. Okay, that completely indefensible posture. Okay, it's only in those positions, and all we're asking for is a reasonable costs. Okay, so that would be the PA fees. That would be the appraiser costs, half the umpire costs. If they should not have had to go down that road to get made whole, engineering costs, and that's really, who drives these costs? The carriers and their defense attorneys. That's who drives these costs. They could settle the claim or they can force the insured to incur all these expenses. But what this law would do is show them their own costs. The legal experts call that internalizing externalities, which is economic technical speak for basically saying, you should sleep in the bed you made. All right. And that's all we're trying to do. Now, the question is, how is the carrier's lobby going to respond to this? We'll see. They'll probably lie. They'll probably make stuff up. They'll probably say, the sky is falling. They'll probably talk about how their premiums are going to go up, but it's all duplicitous. It's deceptive. It's just not true. They're experiencing record profits right now across the country. And even if casualty events are on the rise, they're still increasing their profit margins. And they can clearly afford to pay millions and millions of dollars for Super Bowl commercials So I don't really think they're hurting financially. So, how are they going to respond? The same way they respond to a valid lawsuit. They're going to make a bunch of red herring, bogus arguments, and hopefully they confuse the jury. In this case, they're going to try and confuse the lawmakers by painting a horror story. So it's really just a matter of us being effective communicators, of meeting with lawmakers who are open and fair-minded, and getting a chance to present evidence on the record as to the need for this law.
I got another question from the audience real quick. Have you heard of the carriers extending coverage and paying for contractor bid items? Then later, when they threaten to have an engineer rewrite their claim and take back approved bid items if they don't agree to a cheap settlement. This really goes back to, actually, I like this question because I've had this question before. If there is items that are presented from a carrier on an estimate, and then an engineer is sent out and the engineer says no, that they don't agree with it, and then those items are removed, but there's still coverage being presented, is that okay?
I want to say this. I know what's going through John's mind right now. And what is the complete fact pattern? What exactly happened in this exact claim? And I'm being honest because our answer will change. I know promissory estoppel might be an argument to throw out there, but again, I would want to know the facts, but I'll let John take it from here.
Yeah.
Being honest.
Legally astute answer there. It does depend. And those are exactly the legal hooks that you would want to reach for as a promissory estoppel argument. To me, assuming this was a valid claim and that the crawfishing, the coverage is improper, this is just a classic case of bad faith, deceptive trade practices, unfair claim settlement practices. The engineers are not authorized to opine on coverage. They don't have a license for that. Okay, they're there to opine on structural damage, maybe causation. Okay, they're not there to talk about what's covered and what's not. And then threatening to have an engineer rewrite the claim. I mean, again, that kind of a threat, that seems like unfair claims handling practices. And especially for these residential claims, like we're not building a bridge here. Okay, we don't need engineers. This is a waste of time and money, and they know. They'd rather pay the engineer's fee than pay for a 2-bedroom house roof replacement. And it's absurd and it's unfair.
You got a strong point there. I mean, where did the forensic engineer even come from?
The insurance company. 100%.
What is that?
They have an expense. They can pay this engineer. And like John said, they're driving up the cost of these engineers and they're forcing policyholders to combat their engineer with the policyholder's engineer. And what does that do? It takes money. What does that do? It eliminates the amount of policyholders that are actually going to take that step to go forward and to fight that insurance carrier. It's 100% the truth.
Yeah. If you're a policyholder or you're a roofer and a carrier hires an engineer or brings an engineer out, you should be consulting with a PA or an attorney, depending on your jurisdiction, because I have never seen a case where an engineer got involved by the carrier and then a payment was voluntarily made. Even when the engineer says this is covered damage, they will still find some way not to pay it. It's like they're pot committed at that point. They've already hired an engineer. We're getting a denial out of this one way or the other. And so if you have an engineer getting involved in the claim, you should be talking to a professional.
I'll be fair. We often meet with engineers on site and are able to show the damages. If you set up the engineer appointment in advance well enough and get the carrier to set the scope of what the engineer is actually inspecting properly beforehand, and then have a camera on them, we have often gotten coverage from a carrier after an engineer was sent out from the carrier.
It's a great case in point, Matt.
Right.
I mean, that's what I mean. Like, if there's an engineer coming out, you better be talking to a public adjuster or to an attorney who is licensed to make an appearance on your behalf, on behalf of the policyholder, and who can hold them accountable to the facts. They can reason with them. That makes a huge difference, having that level of accountability.
Does an insurance carrier have the right to send an engineer who's not an agent or an adjuster, isn't licensed? Let me qualify this. If the policy says that the term "we and us is the employees of the company that wrote the policy. Do they have the right to force an engineer that's a third party on the insured?
Yeah, or I think Remington probably has the same idea I do here, which is that, they have the discretion to investigate the loss however they want. And the carrier has a certificate of authority to bear risk. That's issued by the Department of Insurance of that state. And that means that they're licensed to adjust and inspect their own losses. Now, that's another reason for the AAA, because there's a double standard there. If you work for the policyholder, you've got to have a bond, license, D&O, E&O insurance. You're held to a fiduciary duty. You got to take a test. Now, if you are adjusting claims for the insurance company, you have to have a pulse. That's about it. and preferably no conscience. Okay. They're going to ask me.
A pulse and a ladder, baby. You're good to go.
I think they force you to wear pants.
I love it. Hey, John, I'm gonna piggyback off of some of the comments that you said earlier about an engineer is not supposed to go to a property to actually adjust the claim. And I can't agree with you more, but they are throwing terms into their reports to tailor towards a claim actually being denied, such as, functional damage and things like that, where the actual claims aren't getting paid because of specific terms that are in that engineering report. I see it over and over again. And look, you can't blind us from the fact that this is actually happening, because it is. There's no doubt.
Frank Dalton, who was on the show just a few weeks ago, he's a PA out of Florida. Do you do work in Florida, John?
Yes.
You probably do. Yeah.
Yep. Yeah, we do.
He's kind of a big deal. And he also has a great hat. Or maybe that was his wife's hat. He looks good in his wife's clothing.
Let's see it again, John, one more time.
Are you talking about
let's
Frank?
see the hat.
This is my hat.
Frank.
John's getting jealous.
My
Yeah.
Indiana Jones
Look
hat.
at that.
You can call me Indiana John.
I was really hoping to get a photo with you.
Indiana John.
Yeah. So Frank says we're not building enough bridges, and the carrier is giving them work to help out. When an engineer goes out on behest of the carrier, often, and there was a blog post from Hague that really discussed this in detail. Often they ignore facts or word them in such a way that it provides the carrier with an out, or what they'll actually say is it provides the carrier with the opportunity to adjust the loss or determine if there's coverage before they say that something is or isn't damaged. There was one post by a very famous engineering firm that discussed the words cosmetic damage. And they say, don't use the word damage. Say it's cosmetically affected, or there's a blemish or something along those lines, but don't say it's damage. Otherwise you're saying that it's damage. Well, no kidding.
That's where we call them denial, turn down reports, turn down specialists. This is literally plausible deniability embodied. They're creating this thinly veiled veneer of legitimacy for illegal conduct. Okay. And if you're an engineer, your license says you shall not misrepresent. Okay. I'm pretty sure that is in the code of every state that licenses engineers. And the only reason I'm not suing engineers for lying and misrepresenting and violating their license requirements is because they're insulated from liability in the code. Only the engineering board can enforce those standards. But that doesn't mean I can't take your deposition.
That's exactly right.
Frank is saying your hat is way cooler.
I don't want to start anything, Matt. I like your hat. Different hats for different weather.
Right.
I agree with Frank. His hat is way cooler.
Matt, you have a better hat. John can jump higher. All right. Can we agree on that? Can we stipulate to that?
Yes,
Yeah.
You can jump higher.
Good mediator, Remington.
There you go.
Is there I just fought you on it. Is there a benefit to a counter engineer report that we produce in that stalemate? What happens next? I guess the stalemate would be if we produce an engineer report, or we send out our own engineer on the insured's
Well-
side against the insurer.
Yeah. So
And it goes nowhere. They say, well, we agree with our expert.
yeah, I
Who's
mean that's
next?
been my experience. Now, different PA firms are set up differently, and just depending on the nature of the loss in question. If so, let's assume that this is at the public adjuster level, and the carriers put an engineer out there, and a PA is on the other side. What I've seen PAs being very successful in doing is just going through that engineer's report and picking it apart with any logical inconsistencies, anything on that report that simply isn't accurate. They described the roof wrong, or they didn't get on the property, or something like that. Just going in and just in a common sense way, reading it and objecting to it. And in fact, my dad, Don Wood, with Suncoast Claims, just authored an engineering report assessment, and it is a spreadsheet with like 40 questions. Yes or no? Did the engineer do this? And if he says yes, then you need to flag it, and you should probably send it to an attorney. And so there are ways of reviewing engineering reports, even if you're not an engineer, that can basically encourage the carrier not to rely on that report, but to give it a second look. Now, I've also seen a PA hiring another engineer, and then the carrier saying, "Thank you for your expert's report. We're going to rely on our own experts," in which case it was a waste of time and money for the insured to hire that engineer. And if you're getting a turn down from an engineer, either get it into the hands of a PA or go ahead and hire an attorney, unfortunately, because you're going to have to overturn that. And it's probably a turn down report. So I would be consulting with legal counsel or with a licensed public adjuster if you've run into an engineering report in a file.
I like to call that a turn down service myself, but that might be something different. I don't know. If the engineer, I've often actually gotten a second engineer involved in a case, especially if it's a large enough loss, just to have two engineers on our end that agree with each other versus their single engineer. I think that it tends to hold a little bit of extra weight, but only doing that in the case where it's a large enough loss. It might be commercial. Maybe they even have professional fees built into the policy. It really depends. Let me ask you this.
Oh, I want to take this question.
Let me say this real quick.
Yeah.
This is no joke. Currently, I have a residential claim. It's been going on for a while. The insurance carrier, very, very well-known insurance carrier, has 3 separate engineers on this one residential loss. This residential loss is under 6 figures. What, again, we're circling back around. If I want to go to court with this actual case, I need to depose all 3 of those engineers. You're supposed to. Now, do you have to exactly? No, but you're supposed to. I mean, that's just chipping away right and left at what that actual policyholder is going to net at the end of the day. It's insane. And I'll leave this is, if there is a causation dispute and I get the file, they have an engineer, and that public adjuster did not hire an engineer prior to me, I am hiring an engineer. The only time I don't hire an engineer if we're talking about scope and we're talking about price differences, but if it comes to causation, I have got to have an engineer to walk in that courtroom.
Mm-hmm. That's right.
What do you think is the cutoff? How big is, assuming you don't have AAA's language and you're not going to get the fee shift, what is the cutoff? At what amount is it feasible, or does it make sense to go down this path with an insured and become a benefit?
In a state like Florida, with a pretty reliable attorney fee statute, it's one thing. In a state like Ohio or Georgia, with a difficult uphill climb legal environment, then the number has to be higher for it to make any sense economically. The better the law is, the more clients can get access to justice.
Do you think an engineer report is a work product?
I wanted to jump on this one. I've seen this before. The question is where the carrier says, we're not going to produce our engineering report, it's work product, and they deny the claim based on the undisclosed report. I have 2 major problems with that. One of them is they're lying. Okay, work product privilege is for lawyers. Okay, it's not for insurance companies. All right, So only if you are an attorney, and this is an attorney work product or an attorney client communication, are you allowed to quote the work product privilege. Okay, so that's simply indefensible from a legal point of view. Now, unless when they say it's work product, what they're saying is we already have a lawyer, and that lawyer is who's hired the engineer as a consulting expert, and he's only giving his opinion to the defense attorney. Well, then technically they're right. That might be covered by work product, but that means you need to hire a lawyer because they already have. The second point is, so the work product privilege, either it's bogus because that's not way that's supposed to apply, or it means they have hired a lawyer and you need to lawyer up too. The second point is, if they're not disclosing their report but they're using it as a basis to deny the claim, that's illegal. In most jurisdictions, you have got to explain to the insured your basis for denying the claim, and if their basis is this report, they've got to give you that report.
That's where we go down the path often. And when someone asks me, what do I do in this case? I usually say, you need to tell the carrier that they can have to provide that report to you if that's what they're using as their basis for denial. I had no idea about the work product thing being an attorney-client privilege thing only. So if they were to say that to you, you're saying that that might be an indication that they have lawyered up and maybe they just haven't said anything to you.
Right.
What about their legal counsel in-house? Is that the same thing?
Well, that's a technical question. It probably goes to the Upjohn rule, which is a Supreme Court doctrine applying to in-house counsel and doing an internal investigation. So, I mean, technically, yes, there could be an in-house counsel justification, but if they're going to deny the claim based on a work product, they need to explain that. And that's where the line between the lawyer representing the insurance company and the insurance company kind of blurs. Because if you're a lawyer and you're acting as a glorified desk adjuster, I want to say you have a duty to the insured, just like the desk adjuster does. Because you're standing in the shoes of an adjuster. Now you are subject to the insurance code. Now you owe my client a duty of good faith and fair dealing. Now you owe my client an explanation for your decision making, versus when you're a defense attorney in your law firm representing the insurance company as a client. That's different. So, there's a phrase that a famous defense attorney likes to say, sort of demonizing roofers who inject themselves in the claim process. Well, I want to say to those defense attorneys who are injecting themselves in the claims process that if you do the wrong thing, you are a defendant. You are a defendant in that lawsuit. Okay. At the very least, you're a fact witness. I'm going to destroy the attorney-client privilege. I'm going to pierce that veil. I'm going to take your deposition, and I'm going to find out why you told the carrier not to pay a valid claim. Or I'm going to make you a party to the lawsuit. We'll just see what I find out in discovery.
And there's case law where if an actual in-house counsel attorney acts as if he's the adjuster and actually adjusts the claim itself, we can actually depose them once it gets into litigation and depose that attorney as if they were the adjuster on the claim. When they outsource to a third-party firm, that's when I believe there's no doubt about it. You got the attorney-client privilege involved in that point.
So any outsourced firm you think is an attorney that's acting as an adjuster?
No. What I'm saying is once they outsource to a firm that's actually, okay, let's get ready for litigation. I think at that point on, given the facts, now there's situations that you and I have been in that I think I could actually say that this attorney is a glorified adjuster, desk adjuster, but the majority of the time, once they get an actual law firm involved, at that point, that's when, the attorney-client privilege would come into effect.
Yeah, and I don't want to make light of that privilege either. This is bedrock to the practice of law, and it ought to be defended in a jealous way, because if the lawyers had to say to a third party the things their client were telling them, the facts that they were telling them so that they could give legal advice, it would put a chill on what people share with their own lawyers. And so it's a public policy, this doctrine of privilege, as well as lawyers should be able to prepare a draft work product and have consulting experts helping them get educated on the case and not have to worry about those drafts being used against their client. So the work product privilege and the attorney-client privilege are super important to the legal profession. It's important to have a candor with your lawyers. And if those privileges weren't there, then people would clam up and they wouldn't share stuff with their lawyers, and it would keep us from doing the best job. However, those privileges should not be abused. And in the case where the defense attorney is handling the claim, I don't think they can claim privilege there because they're essentially acting as an adjuster, and they need to be forthright with their policyholder.
Let's give an actionable item here. If the carrier were to say, we're not going to provide X to you because it's work product, they might be saying that they have lawyered up without actually getting the attorney involved. Should the contractor be getting a public adjuster or an attorney involved right away? Or is there something that either a contractor or a public adjuster should be doing at that moment? Such as maybe asking, did you get an attorney involved? What's going on? Something like that.
Yeah. I mean, depending on the rules in place, maybe the policyholder should ask those questions so that the contractor's not kind of putting their neck out there. But yeah, I mean, you can say, have you retained counsel? Why are you invoking a legal doctrine that only applies for when attorneys are involved? You know, we're just trying to adjust this claim here. I'm asking you a simple question and you're claiming some legal doctrine. You know, I just want you to explain yourself and just use lay term, right? Just speak in common language. Because if this ends up in litigation, all of this corresponds, and put it in writing too, okay? All this goes into the record. But yeah, I mean, there's something you can do. You can ask those questions, ask the open-ended rhetorical questions. That's not negotiating. That's not asserting anything. Just ask and see what they say. But as a general rule of thumb, if the carrier is denying your claim and not telling you why, your rights are being violated. And you should be talking to a licensed professional who's authorized to negotiate for you.
Just to clarify too, if the engineer report is the report that they're using as their basis for denial, even if an attorney is involved on the opposite side, they still can't use the work product privilege because they're using that report as their basis for denial. Is that correct? That's
the position I would take. Yeah, I mean, and if they want to double down on that, we'll go to court about it, and we're going to ask the judge, you know, what's the role that this lawyer was playing? Is this appropriate? And we'll have a judge decide whether that privilege applies.
Yeah. You know, I've handled thousands and thousands of insurance cases and claims. I've had files come across my desk where they say to a public adjuster or maybe a contractor, look, well, I'm not going to give you this engineering report because this is work product. Once I get the file, they hire their attorney. I request that report. I have never not received that report. That just tells you something. Not one time in my career have I not received a report that they're relying on to deny a claim itself. And so I think it's a bunch of BS.
That's true for me too.
I have to tell this anecdote because it applies in this context. So, and this is another thing. If you're a carrier engineer, you need to listen to this because the carrier's lawyers are not your lawyers. They represent the insurance company, and you're a hired gun, and they will throw you under the bus if they have to. So we had a case where, and it's settled confidentiality agreement. So I can't name names, but this is a prominent insurance company, and they hired one of these turndown specialists, these engineering firms that you guys know about. And the carrier's lawyer, when it went into discovery, told the engineer, go ahead and produce this file, knowing full well it was incomplete because the engineer had a 3-inch hail report in their file, and they had multiple drafts of initial reports that had been revised in favor of the carrier. And so really damning information in the possession of this engineer, and they twice violated a validly issued subpoena to produce their files and twice lied to the court, misrepresented to the court that they had given everything in response to the subpoena issued by that court. And so we took a deposition of this engineer, and we found out about the files. The engineer ended up hiring his own defense attorney, who produced everything and was like, "Oh my God, you should have given him this. Why didn't you give them this?" And he said, "Well, the lawyers for the carrier told me not to. They blessed the work product I did disclose, which was totally misleading." And then the carrier settled the claim, so they're out. And we're having a contempt hearing, and the judge says, well, this is kind of weird because the culprit here is the carrier, and they're not even party to the case anymore. So we're now having a contempt hearing on this engineer who is just doing what the lawyers for the carrier told him to do. and we asked, and we're seeing whether we get it. We asked the judge for a holding of contempt of court for that engineer, but with just nominal damages. We said, Your Honor, we need you to vindicate the point that you have to comply with a validly issued subpoena. Okay, and it's important for these are not like the first time this engineer has got a subpoena before. These are repeat players. They do this all the time. They get thousands of subpoenas a day, and so they need to know you got to produce your files. And the lawyers for the insurance company, they don't represent you; they represent the company, and they need to comply with the law.
Let me ask you a question. And there might be some kind of laws that protect attorneys in these cases. If the defense counsel is found to have been the one directing that engineer to write something that was a misrepresentation or withholding information, can that defense attorney ever be called to task on that directly?
Yeah.
Yes.
Yeah. I mean, committing fraud on the court is certainly sanctionable. The bar rules require us not to misrepresent. So there may be a disciplinary matter there. Now, a lot of state laws really insulate the lawyers in what they do in front of court. You get sort of quasi-judicial immunity for the things that you're doing as a lawyer, so that if your client's misconduct doesn't get imputed to the attorneys who are really officers of the court just trying to do their jobs. But it just depends on how egregious the misconduct is.
I really like the idea of some of these attorneys that I've dealt with just going to jail. I don't know, but it just sounds so awesome in my head. I'm just gonna daydream for
that's a dream world. The bar would slap them on the wrist at first, maybe do some type of sanction, but for them to go to jail, it's got to be just widespread fraud throughout many of claims. I'm just being honest.
Yeah, it's unlikely to ever to happen. I mean, you have to work so hard to become a lawyer and to be licensed. And at the end of the day, the lawyers are going to do what's right. I trust that. And when they don't, that's really the outlier. Let me be clear here. I have the utmost respect for the defense bar. Everyone deserves their defense. Everyone deserves a lawyer. And it's important that we maintain civility here. I mean, obviously we can get pretty heated about this because we see the consequences of the insurance company's behavior, and we impute that intent to their representatives. But really, if a lawyer is being unsavory to you, understand they're probably following their client's instructions, right? Their client probably told them, be as difficult as you can here. All right. So people love to hate on the lawyers, but understand we do what our clients tell you. So if you think the lawyers are bad, it's probably their client.
Very true. Very true.
How many things have you done for your client that you probably shouldn't have?
That I shouldn't have?
You should answer this on the record.
Zero. No, John is exactly right. We can only do what our client tells us to do. And that comes to settlement, across the board, anything of that effect. It's all about the client. So I get along very well with defense counsels, especially here in the state of Georgia. I really do. I mean, that's what was one of the themes that we have, love, not hate. That was a couple episodes ago. Yep. And I get along with a lot of defense counsels, and I think it benefits my client because I have that relationship with defense counsel. I really do. I think I have better settlements because of that.
I think a lot of PAs have the same experience, that when they get along with the opposing adjusters, things go a lot better for their client.
Yeah, let's speak to that. Civility, courtesy, professionalism, respect. We've kind of been using some heated language here because we're talking about the worst offenders,
right?
When we're talking about bad faith. But I think that there is a lot to be said for courtesy, professionalism, respect, giving people the benefit of the doubt. Everyone's got their jobs, they've got their orders that they're trying to follow. But the more civil you are, the more courteous and professional you are, the more likely you are to get a fair shake, and to really deal with the merits of the claim and not any of the other noise.
I'm going to bring this question up. The game that I see is a rough draft versus the final report with engineers. We had a file where Donan agreed with us on site and said he would give us a report on December 22nd. Last week, the adjuster told me they were awaiting the finalized report. So the question is whether or not, when you know that there was one version of it and it's being changed over and over again, is the adjuster talking to the engineer and telling them that maybe asking questions or maybe even directing them to take certain things out and put certain things in? Do you think that that is fraud or maybe steering or something along those lines? If they steer their expert to say something specific and then rely on that expert's report, is that bad?
Well, I mean, it sounds bad to me. I mean, we don't tell our experts what to find. You have to have, assuming you're in federal court, they have to comply with the federal rules of evidence. They have to provide an opinion that is objective, that is unbiased. Okay. And you have to disclose to the court the basis for that expert's findings. Okay. And so what research did they do? What interviews did they do? How did they arrive at these opinions? And so the opinion that they offer to the court has to have a proper pedigree. Okay. It can't come from the defense attorney. And usually the communications between the lawyer and the designated testifying experts, those are not privileged. Okay. Now, between the lawyers and a consulting expert, that would not need to be disclosed. But the communications between a desk adjuster and an expert, or if an attorney's acting as an adjuster and their expert, that's part of the claim file. Okay, that should be discoverable. And if they're telling them what to put in their report, that is definitely improper and arguably fraudulent, if not simply bad faith and deceptive trade practices and unfair claim settlement practices.
I want to bring this back up. In states where there isn't a lot of leverage, there isn't any kind of fee shift, even if if litigation is filed, if a suit is filed, there really seems to be an issue for the smaller claims more than anybody else. Is there any other option other than having the fee shift kind of language that AAA is looking for that is a viable fix for that market?
I think you have to have a fee shift. I mean, other than that, what is the other option other than paying for a PA, an attorney, an engineer, everything else because if you don't do that, what is the insurance company going to do? They're not going to properly pay claims. They're going to deny claims, and they're just going to get away with it. It's either you be proactive and spend money and fight your claim, or you don't. And that's just the two options, honestly.
I mean, this maybe it sounds extreme, but if you're an insurance company and you have an in-house policy of systematically denying, delaying, underpaying valid claims, you should have your charter revoked. You should have your assets liquidated and put into a settlement trust for policyholders, because that's highway robbery. Most policyholders are compelled to take out a policy of insurance by their financial institution. They have no choice but to enter into a contract with you, and you're just going to stiff them like that. You shouldn't be in this business. That's a racket. Okay, that's a racket. How is that any different than highway robbery? They have a compulsion to buy your product, and you never intended on making good on that. That's fraudulent.
We question engineer reports a lot. We see it more lately, where the adjuster refuses to take the questions back to the engineer. The engineer will not respond directly. Desiree is my business partner. And what she's trying to say is, if we ask the adjuster to ask the engineer a question and they refuse, is that an act of bad faith if they're refusing to, maybe because they know what the answer might be?
I'll let you take this, John. I think I need more facts, but the thing is, just one little quick note is you are making the insurance company spend more money if you do that at the end of the day. But I'll let John take that.
Yeah, I mean, the engineer doesn't report to the insured. They're a hired gun for the insurance company. The problem is when the adjuster for the carrier hides behind the engineering report, which is predicated on false statements or a misunderstanding, of the loss or the nature of coverage, that's when it makes sense to try and get those questions to the engineer and say, well, would you have had this opinion if you knew such and such? Because it looks like your report's based on a misconception. And when the adjuster refuses to convey that and they continue to double down on that engineering report that's premised on a false statement, for example, I don't know that it sounds like intentional. It sounds like a breach of contract. It sounds illegal to me, but it's too easy to call things fraud when they're simply improper. That sort of turns the temperature up quite a bit. But this behavior is all too common, and that's why AAA exists. We're looking for systemic answers to this, because if the carrier's hiding behind an engineer report, as Remington has spelled out, there goes 3/4 of your recovery if you're a residential claimant, trying to hire all the professionals necessary to get that claim settled. And so you need to have those reasonable costs need to be reimbursed. Otherwise, you're going to never have indemnification.
We really have to try onto this image. My natural place to sit right here makes me look like a goat.
You got the horns going right
I've got
here.
the ears sticking out of both sides of my head.
It looks good on you, Matt. Looks good on you.
Thanks, John. So we've got you basically acting or talking as if you're APA, AAA, and for Green, Klein, and Wood. We really want to talk mostly about AAA and their mission. I know that the fee shift language looks like it's gaining a little bit of traction. Is there anything going on that you're able to talk about possibly in Illinois?
Yes. Yeah. So, we don't want to put all of our cards out there because, you don't want to invite the evil eye. But we have multiple bill sponsors for this language in a number of different jurisdictions, and we're working on that. But I think what's more important is we already have legislative victories to brag on. I mean, and it's not always offensive, right? The best offense is a good defense. You hear a lot of coaches say that. Defense wins championships. Everybody knows that. But we've been able to defeat some really bad bills. And members of AAA have gone to the state houses in several different states now and said to the lawmakers there, you can't let this get enacted into law. This is what it's going to do to policyholders. This is a totally lopsided proposal. It doesn't address any real problem. It just benefits the insurance carriers unilaterally. And so we've stopped multiple bad laws from going forward already. One of these laws was proposed by NAPIA of all parties, and we sent a member there to testify against it, and they defeated that bill. Thank goodness. So we're playing offense and defense at AAA. The American Adjuster Association is there to stop bad bills from coming into a place that would affect the consumers of insurance products, and we're trying to push for these reasonable reforms to help make them whole again.
A bill proposed by NAPIA. I'm not familiar with that. What state was
we
that?
Can have it. This was in Wisconsin.
I got some stuff to look into. Unless the audience really wants to know.
Yeah, well, you should have Mike Lindhurst from AAA come on and talk more about that. I mean, he was really spearheaded this, and I'm glad I got to join this. You want to be part of the solution. You want to be part of the reforms that are necessary. I encourage everyone to reach out to AAA and get involved. I mean, this is brought to you by people working in this industry. The priorities are going to be dictated by our memberships. I told you you've got two broad priorities. One's offensive, one's defensive. But, what are we going to be focused on next year? It really just depends on what the carriers come up with next. I mean, it's like playing whack-a-mole with these guys across the country.
I often have conversations with people in my state that are, I'm the president of GAPIA. Remington's actually on the board of GAPIA too. So you probably get the same stuff, but often I get questions on what it is that we can do and going forward and trying to, there's this issue and then there's that issue and we don't have any kind of leverage, and it's because we don't have appraisal in this state that actually works because of some bad case law. We don't have any kind of fee shifting for unless there's bad faith that's assigned. there's all kinds of issues. The beauty of the fee shift language from AAA is that one sweeping motion would solve almost all of our problems. I really don't see anything that wouldn't improve on the consumer side from that language being passed. I don't see any drawback. I need to post that language in the comments a little bit later, and you guys can ask questions even after the show is ended. And I know that John and Mike Lindhurst and anybody else from AAA, I'm actually a member myself, would be happy to answer those questions. But can you think of any kind of a drawback that consumers might see because that language exists in the code?
Well, let me be clear. The language is already the law in almost every state of the union. Almost every single Supreme Court or appellate court at the state level and the federal court system in the United States has recognized the doctrine of consequential damages. This is not new. What we're saying is just in the context of insurance claim adjustment and the thousands, if not millions of lawsuits that are bred across the country because of carrier misconduct, in that context, the doctrine of consequential damages means that the reasonable costs incurred should be reimbursed in addition to the settlement. Okay, so we're just trying to make that specific in the context of insurance claim disputes. We're not introducing any new laws. We're not introducing any new concepts that the defense bar is not aware of or that their clients have not already priced in to their actuarial models. Okay, this doctrine, as I said, I found a 15th century Italian jurist talking about the doctrine of consequential damages. Anyone that's ever gone to law school, maybe your first semester in law school, you study the case Hadley versus Baxendale in your contracts law class that articulates and probably the best prose out there. That's why it gets cited so often, that the breaching party pays for the foreseeable consequential damages. And the only real question is, was it foreseeable that the insured would have to incur those costs? And you bet it is. You bet it's foreseeable. You know the carriers see that coming.
Let me be clear on what John is saying. In every state, there are breach of contract claims, and there's law. On this breach of contract law, the case law is stating that if you win that breach of contract claim, if you go to court, that the court is supposed to award you any incurred cost that come with proving your breach of contract. However, other states such as Georgia, for some reason, the insurance company is up on a pedestal and they're somewhat immune to those actual common laws in the states that John's talking about. Is that what you're trying to say, John?
Yes, it seems like we're asking for something extra here. We're really not. And that's the risk, is that the carriers are going to, surprise, surprise, misrepresent what we're actually doing in order to scare lawmakers away from this position. What we're asking is for the lawmakers to just make it automatic. Okay, bake this into the insurance code. We shouldn't have to go hire lawyers to go get an award. This needs to be automatic. If you're forced to hire professional representation to get paid what you should have been paid in the first place, that those fees should be reimbursed. And that's just to honor the principle of indemnification. And it's to bring the insurance code into alignment with common law, which means judge-made law that's been on the books for centuries. It's just a bedrock legal doctrine in Western civilization. So, we're not asking for any exotic remedies here. We're just trying to close a loophole and to address a market failure.
Not only do the laws protect the insurance carriers and they're somewhat immune to these types of damages, but like, for instance, in Georgia, we all have bad faith. We all know that, 3346. However, to get that bad faith, I mean, you're talking about jumping through hoops and hurdles and everything else under the sun. It's the only industry where I actually have to send a 60-day demand outlining their bad faith, and they have 60 days to pay it. If I contracted for Matt to come to my wedding and sing and he doesn't do it, I don't have to send him a 60-day demand.
I'm not doing that.
I'm just saying, like, it's all these other layers of protection that these insurance carriers do have.
It's
that
a racket.
any other company. Yeah, exactly.
Not only does everyone have to buy products from them, but they get all these special privileges and immunities and all sorts of legal insulation from their bad claims handling. I mean, and part of the problem is you'll get some unscrupulous people that are running claims or committing barratry or they're committing insurance fraud, and those are held up as object examples to the lawmakers, and they're saying, see what we're dealing with here, all this bad action on the part of policyholders, and they change the law and bad facts make for bad laws. So that's why you and all of your colleagues and everyone that's listening to the show, have scruples, do the right thing. You gotta conduct yourself like a professional, be ethical, don't lie in a claim, don't bend the facts. Just be objective and honest, because we really can't afford any of those unforced errors. When you have somebody that's running an unethical shop, they end up being Exhibit A in the next legislative session, and that hurts all of us. So let's all raise our standards, only present valid claims, only tell the truth, or I should say, tell the truth only. And I think that we'll be better off here. But it is an uphill climb. You asked Matt earlier what could happen if this gets proposed, how the carrier is going to react. They're probably going to, like I said, they're going to say the sky is falling, it's going to raise premiums or whatever. But we just have to fight here. We have to fight for it. And what we're doing now is we're building coalitions. We're laying the foundation for a sustained push. One of our leaders in the organization just quit his day job and is going to take this on full time at AAA. So we're putting our money where their mouth is. I mean, to be an advisor, you have to commit thousands of dollars and substantial time. I can't miss a board meeting or they're going to remove me. This is a serious commitment that we've made to try and push these reforms through. We're building a coalition. If you work in the storm restoration industry, you got to be a part of this. We need your support. And this is nationwide, and there's strength in numbers and there's strength in diversity. So we just got off the phone with the president of a major roofing convention. They represent the roofers in this state, and they're going to look for ways for us to work together because they see it. Their eyes are open to the alignment and how effective that divide and conquer strategy has been. And unfortunately, if you're promoting the unauthorized practice of public adjusting laws, look, I respect PAs. My dad is a public adjuster. My brother's a public adjuster. A lot of my work comes to me from PAs, and I think they add a huge value to policyholders. But one of the unintended consequences of the licensing regimes is that it's criminalized contractors for trying to help residential policyholders. And we need to deal with that because that's not the intent. All right. The whole idea behind the PA licensing regime is to protect the consumer. And if one of the side effects is that consumers are getting denied their professional representation, we need to address that. So that's another thing that we're going to be working on. And we're going to build coalitions here because the divide and conquer strategy that's pit PAs against roofers has been extremely effective. Pitting the plaintiffs' lawyers against PAs, that's also been effective. We all need to band together here and protect the rights of the policyholder, because if their rights are eroded, all of our rights are eroded. We have less leverage. There's less we can do for them, and it impacts us all on the bottom line. So it's a matter of enlightened self-interest here that you should support the AAA and help us with these legislative campaigns.
So if they want to join the AAA, they have more questions, where should they go?
You can go to AmericanAdjusterAssociation.org. You can reach out to me on Facebook. Somebody just posted a link. AmericanAdjusterAssociation.org/membership. Reach out to any of us that are involved. Matt Behrens is on the board. Scott Green is on the board. Dave Miller, Mike Lindhurst, myself, we're on the board. And now folks like Don Wood, he's joined as a state board advisor in Texas. TJ Ware has joined in Texas. Steve Patrick has joined. He's a really important voice in our industry. Steve Patrick was an early joiner. So contact any of the leaders in our industry. Paul Reed, he's joined. So any of these people, they get it. They understand how important this is. They become a part of this movement, and they will direct you. They'll get you introduced to the right people, and you can process your membership application. And we have applications at various levels too. So if you're a solo operator and you can't afford a big outlay, we've got room for you. If you want to make a big splash and really make a big difference and be involved as a leader in your state, we've got state level advisory memberships for you too. So just reach out to one of us or apply online.
That's perfect. Well, John, we went over time as we tend to do. I really appreciate you hanging in there with us, especially through all the technical difficulty we have. We had a great show, though. I learned a few things that I had no idea about, and I might actually ask you a whole bunch of questions going forward. You are going to brand my bull at some point. I want to bring that up before we get off. You've got this awesome Dragon Slayer logo. That's what's on your hat. This is a course or a class that you put on regularly. How often does that class go down?
We're going to start doing it more. I mean, COVID really got in the way there. We're doing it at least once a year. The Dragon Slayer training is for public adjusters. We go over the main legal hooks that PAs need to know. So it's really targeted on that audience. And we'll be doing that again as soon as we're safe to do large gatherings 2021. We might just do one over Zoom soon, and I'll be sure to send you an invitation.
No, I definitely want to go. That'd be great. And once we get that bull finished and our booth set up for the Win the Storm, I'm going to have John come over and literally brand the Dragon Slayer logo right on my bull's ass. And it's
going to be a branding event.
Oh, it's a branding event. We're gonna brand So that'll be leading up.
Now that I'm a rancher, we gotta bust out the ranch.
It's perfect.
John, it's been an absolute pleasure. It's great to actually talk to an attorney, apples to apples, about things. Man, I don't know if I've had an hour and a half conversation with another attorney where we see eye to eye on majority of things. I mean, seriously. Well, I mean, everybody, hey, look, just like you ask a contractor, give an estimate, you're 10 contractors, you're going to have 10 different numbers, just like an attorney has an opinion. So it's great.
I've heard nothing but good things about you, Remington.
Yeah, man. Hey, you as well, bud. And I look forward to it, man.
Thanks,
All
guys.
Right,
appreciate being on the show.
See you, bud.
Take care. That was fantastic. Who we got lined up for next week?
Next week, we've got Andrew Behrens coming on from C3 Group.
So I did a review of the Xactimate course that Andrew Behrens of the C3 Group is putting on. It's a level 1 and level 2 Xactimate training course so that you could take the test at Xactimate to get certified. And it's a great course. And Andrew is, I want to say retarded intelligent, but I don't know if everybody would understand what I mean by that.
Too smart for his own good.
Right. That makes better sense. That retarded intelligent doesn't make sense at all.
That's why I'm here, guys.
Yeah, thank you. I'm so glad you're here. He's ridiculously smart. He's wicked smart. And he's going to be on the show, and we're going to ask him all kinds of weird Xactimate questions, see if we can stump the guy. He doesn't realize we're going to do that. I doubt he watches this show, so he's not even going to hear this part of it. I'm looking forward to having some really intricate, weird questions for him. And you should too. If you're using Xactimate and you have a weird problem, you should join us on that show next Tuesday at 4 p.m. Eastern. And let's try to stump the guy. I really want to.
Let's do it. I look forward to next week.
I think we should keep score. How many times we get him to say, "Oh,
Let's
I don't
do
know."
that.
I'm going to look into that.
Olivia, we got to keep score. Can we do this?
We
Absolutely.
can make a drinking.
I
game out of it.
have my board over here.
Oh,
I'm in.
The audience can drink every time he gets stumped. You get a shot.
And
gonna be great.
Facebook user is identifying the fact that you miss Remington so much when he's not here.
It's true. It's true. You guys recognize that the show is way better with him on it, right? It's so much.
Absolutely.
I suck without him.
hey,
You complete me.
it's meant to be, people. Meant to be.
Serious bromance.
There you
It's
go.
very uncomfortable in this room.
Love you, man. All right, guys. We'll see you next Tuesday at 4 p.m. If you have any questions on today's show, or you want to ask questions about AAA or to
Gapia.
John Wood directly, put them in the comments on either Facebook or YouTube. And I know that he's going to go back and he's going to review those and answer them if he can. We can always answer your questions as well. But definitely get that conversation going. There was so much on today's show. I'm really excited about it. Let's keep the conversation going. I want more. All right?
Yeah, we've also got a ton coming up with Gapia too. So if you're in Georgia,
Oh,
you're
yeah.
PA in Georgia,
If you're a public adjuster
sign
in
up.
Georgia, we need you to reach out to Gapia immediately before this Thursday, which is the 28th. reach out to us. Go to gapia.org. Reach out to myself through a private message. You can reach out to Remington, any of the other Gapia board members. Please get with us right away. If you are a public adjuster in Georgia and you are not currently a member of Gapia, we need your help.
Yes,
Let's
we
do
do.
this.
Yes,
All right.
we do.
All right, you guys have a great day. We'll see you next time.